Good afternoon and welcome back to Bitkom's second day of the Privacy Conference 2025. Sorry for the short delay, but we had some small technical issues, but we sorted them out. I have one change in the agenda. We will be hearing the keynote from Dr. Des Hogan from the Irish Data Protection Authority first, and after that, hopefully Emily Keeney will have joined us as well, and then we will hear her keynote, and after that the panel will take place. So I can see Mr. Hogan on my screen. I am very happy that you're here once again this year, and thank you for your time. And the flexibility.
No problem. Thank you. And good morning. Good morning, everyone. My name is Des Hogan. I'm Commissioner for Data Protection and Chairperson of the Irish Data Protection Authority, and it is a real pleasure to be with you again, although unfortunately, again, not in person, but I will make it hopefully next year, the year after, in person. So I'm just going to speak today about the priorities of the Irish Data Protection Commission and some of the challenges we face. And I'm going to do that from an overview perspective, like from a higher, I suppose, values-based perspective. And then I think in the panel, we will get into some of the granularity about the particular kind of cases and work. So the priorities for the Irish Data Protection Commission really include, working towards fair, coherent, and consistent regulation. It is very important that organizations and companies understand what is expected of them when it comes to GDPR compliance. As a fundamental rights body under the GDPR, under the Charter, data protection authorities, we must be values-based. So again, the GDPR is a principles-based instrument. So for the DPC, a priority is to be values-based and issues-focused. We regulate a wide sector of society, every sector really. We regulate the public sector, we regulate the private sector and the voluntary sector. So this very extensive remit means that where we regulate every entity in Ireland that processes personal data, that has to mean that our regulatory strategy responds to how we can be selective. And the way we do that is we focus on high risk and large systemic issues. And this is a focus on risks and harms which underpins our work. One of the priorities we have is to meet the expectations of Irish and European Union citizens, where we have responsibility for, and I'll come back to that in a moment. But it is also in the context of our cross-border work, and the GDPR is a very unique instrument where it actually legislates for cross-border collaboration, coordination, cooperation, and co-regulation in some respects. So it is very important for us, and a priority for us is to work closely with our peer European Union and European Economic Area Data Protection Authority peers, and with the European Data Protection Board, where the board has responsibility, including for setting guidance, opinions, and the ensuring the consistent approach. A priority for us is to provide clarity to organizations and feedback, and this is important to support innovation, to ensure that companies, when they are looking at launching new products in Ireland or in the European market, where we are the lead supervisory authority for the company, that they have a bit of clarity about what's expected of them. And when they come with proposals, for example, with a data protection impact assessment where there's high risk processing of personal data, that we give feedback on that and we look for improvements. And we do that in consultation with our peer regulators across Europe, of course. We also look at addressing the priority areas set out in our own regulatory strategy in Ireland, and that includes children, vulnerable adults. And another priority we have is concluding the remaining large-scale inquiries which were commenced immediately after the GDPR came into effect back in 2018, 2019, 2020. A lot of those inquiries include novel areas of interpretation. So the data protection authorities are working, I suppose, ahead of the courts these cases, these inquiries, when they come to fruition, to conclusion, are often met with legal challenge, and the European Court of Justice will, in time, no doubt, rule on some of these novel areas of interpretation. But we see that changing in a very regular basis, and I'll come back to that also. Um, we also, as a priority, need to respond to the advent of new technologies, and we have attempted to do so in relation to artificial intelligence over the last 2 years. And we might come back to that a little bit more in the panel. So, as regulators, we have to come back and focus on our legal mandate. And our legal mandate really is that the risks and harms to individuals arising from the processing of our personal data um, dictates where regulators need to place their attention. We also, I suppose, as a publicly funded, taxpayer funded organization, statutory organization, independent under the EU treaties, need to be responsive, and we need to be relevant. Well, I move on to challenges now. Again, some of these, you will see some of these, the earlier priorities flow into challenges. So, meeting an ever increasing workload, we find that the number of complaints are continuing to rise. In 2025, in the months of May, June, and July, each month was a record month for complaints received in the Irish Data Protection Commission. So, um, that, again, the cause of that we will have to consider and reflect on. But it is the fact that GDPR and knowledge of GDPR is rising, and people have the right under the GDPR to make complaints to their national authority, or those complaints can be transferred when it's cross-border to the responsible authority, which in some cases can be the Irish DPC. So how do we meet an ever-increasing workload? Being relevant to what and where the greatest risks and harms lie. Being responsive, as I said, the challenge of being responsive to citizens, to business, to organizations. And the way we try to do that is we meet with organizations and representative groups, listening to their concerns, providing guidance, and perhaps revising guidance, perhaps giving workshops, um, and in some cases, a little bit of clarification. For example, we had a situation where a bank was sending in a lot of um, notifications for data breaches, but they were low risk, not medium or high risk. So a little bit of guidance can mean that an awful lot of work on the organization side can be dealt with more efficiently. Um, in addition to being responsive, though, as national data protection authorities, and again, if we think of the GDPR, it affects all areas of society. Um, we also have a role in influencing public policy and in standards, in raising awareness in a balanced manner that aligns regulation and innovation, enabling citizens to benefit from safe and responsible new technologies. It is in nobody's interest to have new technologies which are not safe or trustworthy, because consumers will not use those products. So it is very important for organizations to engage with data protection authorities to ensure that we can reach that place where new products and services can come in a safe and reliable way. And then again, back to meeting the expectations of society and organizations. And the expectations of society are changing. If we think about the GDPR, which came in 2018, we see that now, some 7 years later, things are evolving, where younger people in particular are using technology much more than was the case back in 2016 when GDPR was coming in 2018. We also see that as data increases, and as iPhones and other mobile technology increase, that more and more of a person's identity is linked to the digital world. So the expectations of society, of parents, of politicians, of leaders, of citizens changes, and we have to make sure that we can respond to that. We also want to make digital regulation more coherent through liaison with our peer regulators, the regulators under the DMA, the DSA, the Digital Services Act, the AI Act, which is coming in, of course. And this interregulatory function, we appointed a head of interregulatory function last year, to push this kind of joined up work, and we want to make this better for industry and for individuals. And then balancing the right to conduct a business, to innovate, to create new products and services with the rights of the individual, and specifically the right to the protection of our personal data, that is a challenge. How do you get the right balance? And there's no easy answer to that, but engagement, I think, is part of the response. Assigning, as a data protection authority, the challenge of assigning the correct resources to the areas of priority, guidance, engagement, supervision, complaint handling, and enforcement. So our engagement. So really the engagement, which is the prior consultation and discussion um, with organizations before they go to market, that has to provide and promote a clear roadmap for compliance, where companies know that they need to come to the regulator with a certain number of months notice, and they need to talk through what is being proposed. They need to receive feedback that needs to work its way back upstream into the engineering works, and things might need to be changed and tempered. There might be more transparency needed, more opt-outs, but it's all about putting privacy by design and default back into the makeup of the product, and that makes for a more trustworthy product overall. So when these proposals come in, one of the challenges we have is to review the proposals in sometimes tight timeframes. And as the lead EU regulator for companies main established in Ireland, this can be challenging in terms of sharing and discussing and collaborating with our European peer regulators. But it is something we are up to and something we are improving on. But there are challenges in this, but there's also benefits. And the other challenge and benefit I might just kind of come to move towards conclusion on is the challenges and also the benefits of the quickly developing case law of the European Court, the Court of Justice of the European Union, often in response to Data Protection Authority regulatory enforcement actions, as I said earlier. So this is a challenge where the DPA, we are interpreting new areas of law, novel areas of law, and then it can take a number of years for the case to work its way through the domestic courts and onto the Court of Justice for clarification. So again, if the Court of Justice changes or alters the interpretation of the law, the Data Protection Authority must alter and must realign its own interpretation to the Court of Justice. And that's not always straightforward. And when companies ask us for what it is they need to do, we always need to say that this is always subject to the Court of Justice and the interpretation, which is a constant moving interpretation. And then the moving again to the concluding those early inquiries which we opened, inquiries into long-established structural and systemic data practices such as online behavioral advertising, while also being sufficiently agile to be closer to the development curve of emerging technologies. We found that when it came to the new AI products, the training models in the last 2 years, that was a very quick learning curve. But I think we are closer on the AI path than we would have been on behavioral advertising when the GDPR came in 2018. So, in conclusion, I think it's fair to say that the priorities of the Data Protection Authority are there to try to be transparent and make clear to all organizations and citizens what it is trying to do, and how it is trying to do it, and to have an open dialogue as much as possible, to work very closely with our peer regulators, and to espouse those priorities, which are often common priorities across Europe, and to land in a place where there is a kind of an understandable and a coherent regulatory framework across the European Union. So I'll close there if that's okay. Thank you.